Okay, thank you everyone for joining us this evening for our conversation with BLAC, Understanding the Human Rights Legal System. So I see some people are still trickling in, but I think I will get things started. All right, so my name is Piera Savage and I am a staff lawyer here at BLAC. And I'm really excited to be joined this evening by Roger Love and Sasha Hart. I will tell you a bit about Roger. He's a human rights lawyer based in Toronto, and he has litigated several cases regarding racial discrimination and anti-Black racism before the Human Rights Tribunal of Ontario, including JKB and Peel, Grant and York Region District School Board, and Wickham and Hongxing Restaurant, Chinese restaurant. Some cases that we'll hear about a little bit more during this presentation. He's also litigated cases regarding disability, mental health, and sexual harassment. In addition to his work before the Human Rights Tribunal of Ontario, he's appeared before various levels of court, including the Supreme Court of Canada. In 2018, he was selected to participate in the United Nations Fellowship Program for people of African descent. So thank you very much for being with us this evening, Roger. We're also joined by Sasha Hart. So Sasha is an Ottawa-based human rights lawyer. She has many years of human rights advocacy experience, both in Canada and internationally. She regularly appears before the Canadian Human Rights Tribunal and has also appeared before the Supreme Court of Canada. She's named as an expert to the UN Women Ending Violence Against Women expert roster. And in addition to being a proud member of the Canadian Association of Black Lawyers, she's also served for several years on the executive of the Ontario Bar Association's Constitutional Civil Liberties and Human Rights Law section, as well as on the National Steering Committee of the National Association of Women and the Law. Sasha earned her LL.B and B.C.L from McGill Law and also holds a master's in international human rights law from Oxford University, where she graduated with distinction. Sasha is very passionate about using her legal skills and knowledge to confront anti-Black racism, gender-based discrimination, and the intersection of the two. So thank you also, Sasha, for being with us. So I just want, before we get started, I want to just note that what you're going to hear tonight is legal information and doesn't constitute legal advice. For legal advice or consultation, we would encourage you to reach out to BLAC, and our contact information will be at the end of the presentation. So thanks again for joining us this evening. We're really looking forward to hearing from both Roger and Sasha about the Human Rights Tribunal and the Canadian Human Rights Commission. And we hope that by the end of this presentation that you will know the difference between the two schemes, and you'll take away some practical tips for preparing for a case. And we'll share some legal resources with you at the end. For questions, there is a function, Q&A function, so we'd ask you to put your questions there, and we're going to get to them at the end. And so before I tell you a little bit about BLAC, I would like to acknowledge that we are speaking to you from, that the land that we're speaking to you from today is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee and the Wendat peoples, and right now home to many diverse First Nations, Inuit, and Métis peoples. This land is covered by Treaty 13, signed with the Mississaugas of the Credit, and the Williams Treaties, signed with multiple Mississaugas and Chippewa bands. We also recognize the history of this land as a site of oppression of Black people and the relation between a history of enslavement and settler colonialism. It's important to frame this conversation through that lens so we all recognize our position and relation to this land. All right, so I'm going to tell you a little bit about BLAC, and then I will hand over the reins to Roger. So the BLAC Legal Action Center is a community legal clinic working to combat individual and systemic anti-BLAC racism in Ontario. We work directly with BLAC folks who are experiencing BLAC racism, and we also conduct policy reform and public legal education sessions such as this to combat it at a systemic level. When we're talking about anti-BLAC racism, what we're talking about is policies and practices embedded within Canadian institutions that reflect and reinforce beliefs, attitudes, prejudice, stereotyping, and discrimination that is directed at people of BLAC African descent and is rooted in the unique history and experience of enslavement and colonization in Canada. The vision that inspires us and the work that we do with our clients is a community, community is a society where anti-BLAC racism is named and meaningfully addressed, where the humanity and dignity of BLAC people are centered, where the laws and the legal system are reflective of the real experiences of BLAC people, and where racial equity and full participation of all BLAC people in society is achieved. So I won't get into too much detail here, but we provide services in the following areas where they are directly related to anti-BLAC racism. So that's employment, housing, human rights, education, prison law, social assistance, and police complaints. We do not work in criminal law, family law, or immigration and refugee law at the moment. I will highlight that we do provide summary legal advice and representation on human rights cases in relation to employment, housing, education, social assistance. So if you do have a legal issue that is related to human rights, especially after hearing this presentation, as I said at the beginning, please don't hesitate to reach out to our intake worker for some legal advice. So now I'm going to hand things over to Roger, who's going to talk to us about the Ontario Human Rights System and how it works. Roger, the floor is yours.
Thanks. I'm pleased to be here today to talk about Ontario's human rights system. And my goal today is really to hopefully demystify the system for the majority of individuals in the audience, and to provide some insights into the litigation process if you happen to become involved in a case that you want to take before the tribunal. I've been told to keep my remarks to 20 minutes, so I'll do my best to canvass the various issues which may arise, but certainly I believe that there'll be time after I speak to discuss some of your questions. So we'll go to the next slide. So I want to begin my talk today by providing an overview of Ontario's human rights system. Back in 2008, our system changed. Prior to 2008, cases, human rights cases, were advanced by the commission, by and large. So if you had a matter you thought you were discriminated against, most individuals would contact the commission, and the commission would investigate the matter. But now things have changed. So I want to explain these changes today, and the changes can be best described as the implementation of a direct access model. Now, before you get your foot into the door, you also have to consider three important things, I would say: jurisdiction, grounds, and social areas, right? So you want to make sure that your case fits within the framework that has been set out by human rights legislation. And that legislation is namely the Ontario Human Rights Code. And then thereafter, I'll get a bit more into the litigation process. And I've broken it down into three main stages: the application stage, the mediation stage, and the hearing stage. If time permits, I'll be able to discuss some of the cases that I've been involved with, or cases that involve anti-Black racism, just so that you get a flavor of how these cases, make their way through the system, and how individuals are able to successfully advance a case in that area. Next slide. So at the outset of my remarks, I referenced, an old system, and I mentioned that to provide you with some context, if you're dealing with the system that we have today. So the system that we have today, as I mentioned before, is a direct access model, and there are now 3 pillars of the Ontario human rights system. Now the commission doesn't do as much, frontline litigation. The Ontario Human Rights Commission now has a broad statutory mandate to promote, protect, and advance respect for human rights. So in a nutshell, the commission's job is to look out for systemic human rights issues throughout the province, and to use their mandate and their special powers under statute to address some of those issues. So for example, the commission has currently used its statutory powers to engage in an inquiry into racial profiling of Black persons by Toronto Police Services. So that's just one example of the ways that the commission can exercise its statutory powers to affect change. The other pillar of the system is the Human Rights Legal Support Center. So now if you're an individual, a member of the public who has experienced or believe that you have experienced a human rights violation, you can contact the Human Rights Legal Support Center, and they can provide you with advice and perhaps representation with respect to your potential claim. You can calling the HRLSC is the first step, and speaking with someone on their intake team is how cases filter through the HRLSC process. And they apply different case selection criteria before a case is selected for representation. The third pillar of the system is the Human Rights Tribunal of Ontario. The Human Rights Tribunal of Ontario is the body that makes decisions with respect to applications. So I'll just explain a bit. If you have a case and you filed an application, that application will be filed with the HRTO, and the HRTO will process the case, and the decisions are made by adjudicators, and so that at the HRTO, those individuals are called chairs or vice chairs. So I'll go to the next slide. So again, am I in the right place? I'm an individual, and I believe that something discriminatory has happened to me at work. I've been treated unfairly by police services. What are the nuts and bolts that I have to consider before I file an application? You have to ensure that your case falls within the 5 social areas and one of the 17 grounds of discrimination. So the 5 social areas are employment, housing, services, unions, vocational associations, and contracts. So if I go back to my policing example that I briefly referenced, generally, without getting into the specifics, that would fall within the area of services, because police do provide a service to members of the public, right? If you were at work and you experienced an incident of discrimination, then you would fall under the employment social area. Now, the other connector or piece that you have to satisfy to ensure that you're in the right place, you have to be an individual who is protected by one of the 17 grounds of discrimination under the code. And I've listed the 17 grounds in the slide for you. They include citizenship, race, place of origin, ethnic origin, color, disability, gender identity, gender expression, and sexual orientation, among others. So if you don't identify as being a person who fits under one of those 17 grounds, then you may not have recourse through the Ontario Human Rights Tribunal. So it's important to make sure that both of these areas, the social areas and the grounds, fall within the scope of the code. Next slide. So generally, in my experience, I find that most individuals, are in the right place, and they satisfy the social areas or the grounds. Now, on this slide, I start to talk about areas where individuals might start to come into a bit of trouble if they're not careful. So if you've experienced an incident of discrimination, you have 1 year from the date of the incident to file an application, right? Exceptions to this rule are very rare. So you want to make sure if something happens and you're thinking about pursuing recourse to the HRTO, that you keep that limitation period in mind. I understand that, when something happens, it can be quite traumatic. And I think there you can look at things from both sides. On one hand, it can be very difficult to rush out the next day to say, hey, I'm gonna file an application, or I'm gonna look for a lawyer and I'm gonna pursue this. So the limitation period can be helpful in a sense, right? I want to put a positive spin on it. You don't have to run out and file your application the very next day. You have a year. But on the flip side, as I mentioned, is you don't want to wait too long, because if you wait beyond the 1 year deadline, your case it's more or less barred. You do have the option of making submissions to the tribunal to explain why you were late. And of course, the tribunal will consider, prejudice to the other side, and your reasons for being late. But you don't want to put yourself in that position. You want to make sure that you're not dismissed on a jurisdictional ground if you have a serious human rights matter. Next slide. So to help sort of crystallize, this overview, or the opening part of my presentation, I've put together 2 case studies to help us think through, the jurisdictional issues, grounds, and social areas. So the first example, I'll just read it out quickly. The Owusus, a Black family originally from Ghana, recently purchased a home in the West End of Toronto. On moving day, they heard a neighbor use racially charged language. Josh Owusu asked their neighbor to stop. In response, the neighbor said, "I don't have to take instructions from a Black man. I'll say what I want." Does Josh, based on what we've covered so far, does Josh have grounds for an application? I'll give you a second, and maybe you can put some thoughts into the chat, or reflect on it yourselves. I'm not a law school professor, but there's some ambiguity built into the fact pattern. So not everything is there, but I'm seeing a lot of no's. Why? Why are people saying no? Okay, I haven't seen anything, so I'll just move on quickly. So this is a, you know, I've as a human rights lawyer, I've received calls of this nature, and it's particularly disheartening, because there's no doubt that, you know, what Josh is going through is disheartening, and you know, would be against the spirit of the code. But the letter of the law, you would have some difficulties in filing an application, um, particularly with the social area. He's a homeowner. The other person who utters a slur in this scenario is just a neighbor, essentially just, you know, another person on the street, is a matter of fact, right? So that person is not his employer, right? If you think back to the social areas that I discussed at the top, they're not providing him with a service. He's not a part of a vocational association or a union with that individual. So the problem that Josh will face is the absence of a social area. The other ambiguity that's sort of built in there is I didn't really specify the date. So we'd also have to make sure that Josh's case was within the 1 year limitation period. Now, the second example, I'll read that quickly, involves Lauren Mills. She's a Black woman from Peel region who was driving her 2019 Nissan on St. Clair Avenue West on May 5th, 2020. A police officer from TPS saw her car moving very quickly, and on that basis decided to follow her vehicle. The officer pulled beside the vehicle to observe the driver before he stopped the car. After the stop, she was ticketed for driving while suspended. Can Lauren's case fit within the ambit of the tribunal? So I'm seeing a few yeses, and questions about whether or not the officer had grounds to stop her. Those are all excellent points. I think Lauren's case would fit more squarely within the ambit of the law. You know, she's a racialized person, so she's protected by the grounds. Police officers are supposed to provide a service, right, to the community, so she has a social area. But the problem that Lauren Mills may run into is that this incident happened on May 5th, 2020. And we are now on June 29th, can't believe the year's half done, 2021. So technically her 1 year limitation period would have come up in May 2021. So she's now beyond the 1 year deadline. So Lauren is probably going to have to explain why she was late, and an adjudicator from the HRTO is going to be put in a position to decide whether or not her case should advance or not. And Lauren's scenario is based on very many of the driving while Black cases that I've litigated and read about, right? Is, you know, officers who may have had an opportunity to view the race of the driver before developing grounds to stop the vehicle, can potentially, not always, serve as a basis for a racial profiling allegation. Now, so let's say, you know, Lauren's case happened within the limitation period, and she wants to file an application to the HRTO. Let's talk a little bit about the litigation process. And I've broken it down, as I said, into 3 areas: the application, the mediation, and the hearing. Next slide. So the application form you can access by going to the HRTO website. Remember, they're the body that you're filing the application with. But if you need help and advice with respect to how that application should be completed, you can contact the Human Rights Legal Support Center. And the intake staff there can provide you with advice on some of the more technical questions that you'll see on the application form. But generally, the application provides you with an opportunity to tell your story, right? What happened? You don't necessarily need to explain the law. I think it's good to have knowledge of the law so that you know that you're in the right place, right? That your case does meet the legal threshold for being considered by the tribunal, but you don't necessarily need in an everyday application to explain the niceties of racial discrimination law. You can state, this is my experience, but you have to be mindful and explain why you believe race was a factor in the unfair treatment that you received. The other piece that I wanted to canvass is naming of respondents. Now, this can be quite tricky, whether or not you're dealing with a police service. You always keep your mind open to the fact that organizations or individuals may not be who you think they are. It's the simplest way I'll put it, right? Even with a public entity like the police, most individuals will say it was I experienced this and it was a racial profiling and it was because of this particular police service. But the police service, under the law, may not be the legal name of that entity. Most applications against the police are filed against the police service board or the chief and the individual officers involved in that particular case. The same thing applies to if you are involved in a shopping while black case, right? The name on the front of the store is a start, right? The business may be carrying on business as the fashion hut, but their legal name might be an incorporated number business, right? Don't get too concerned if you're not. I mean, take steps to try to ascertain the legal name of the business, but don't let it make you run afoul of the limitation period. If you know the name of the business, you know its address, its location, and some other details that are usually publicly readily available, if you file the application, by and large, the onus will be on the respondent to sort of confirm their legal name. There are cases where the tribunal will come back and ask you to confirm things, but don't get too hung up on that point, but be mindful. You want to know who the legal entity is that you're dealing with. The other major part of the application form that I often get asked about is what kind of remedy can I get for racial discrimination? So the remedies can include general damages, and general damages is money, right? Compensation to somewhat make the victim of discrimination whole, or to compensate them for the loss to their dignity and self-respect, right? It's not pain and suffering as you hear of in other sort of courts and what you might hear on TV. Before the HRTO, they speak about damages for dignity and self-respect. There may be other pockets of monetary damages that you can claim, special damages, and special damages refer to a specific monetary loss that flows from the discrimination that you experienced, right? So an example might be if you are a Black person who applied for an apartment and you believe that your race was a factor in the landlord not renting that place to you, and as a result you had to spend additional money out of pocket to secure another place to live. That additional money that you had to spend can be specifically quantified, and you can ask for it in your application. There's no guarantee that you'll get the amount that you ask, the specific amount that you asked for, or you'll get the general damage that you feel that you're entitled to, but you're certainly entitled to ask. Many people, in fact, are attracted to the human rights system in Ontario to receive a non-monetary or public interest remedy, right? So, so a non-monetary remedy could include something like a letter of reference. It could be, while not often awarded, it could be something like what we would call like in the nature of specific performance. So, if you were unfairly denied an opportunity to get housing, maybe that opportunity should be afforded to you. A public interest remedy could include things like policy development. So if we go back to our policing example, it could involve training for police officers, or training is general. I won't complicate things too much. Training or the development of a new policy around use of force, things of that nature. So there's no, you're not getting any money in hand, but the public interest remedy is designed to ensure that the discrimination that you experienced hopefully won't be experienced by another individual in the future. So you completed your application. The next stage for most applications is mediation. Mediation is a voluntary process. So in your application, you will be asked whether or not you want to participate in the mediation process. By and large, it's a good option for most individuals. You're not forced to settle your claim if you go into mediation. If you do not, if you enter into the mediation discussions and you're not happy with the settlement that you're offered, you are entitled to advance your case to a hearing. That being said, I will note that most cases before the HRTO will settle. Most individuals, they weigh the factors, right? Even if you get to a hearing, you might lose. You might not get the money that you think that you're entitled to. And it may take some time before you get to a hearing. So some individuals choose to settle their case at mediation. The HRTO has a structured mediation format, so you will have an opportunity to appear before a member of the tribunal who will help try to settle your case. Most of the mediations were conducted in person. With COVID-19 and the digital revolution, a lot of these mediations are being held virtually, as I understand now. The other, I talked a little bit about the negatives that might push someone to settle, but there are positive aspects to a settlement as well, right? Oftentimes in a mediation, you can craft a remedy which the tribunal, may not be prepared to award. So if the respondent is willing to provide something to you that you want, many of my former clients have decided to take it. And I provided just one clause from the grant for York Region District School Board settlement at the bottom of my slide for you to review. And a more fulsome copy of that minutes of settlement is provided on the Human Rights Legal Support Center website. So to clarify, if you go into a mediation and you reach a settlement, the settlement will be reduced to writing, and that document is called a minutes of settlement. And that will set out the specific terms of the agreement, and that agreement can include all of the remedies that I previously discussed. So it can include a public interest remedy, it could include a monetary remedy, and it can include a non-monetary specific remedy for the harm that you've experienced. If you take your case beyond the mediation stage, then you're heading to a hearing before an adjudicator at the HRTO. And that's when you really have to start to drill down on the evidence that you have to support your claim and the legal test, right? So you want to be able to establish that you have a prima facie case of discrimination, right? And prima facie, just a Latin term. You want to, another way to explain is you want to make sure that you have a threshold, your case at least satisfies the threshold for making out a legal claim of discrimination, right? And so in order to do so, I've pointed out 3 points on the slide. You must have a characteristic protected by the code. You must have had some type of adverse treatment, and the protected characteristic had to be a factor in the adverse treatment. The word factor is key because so many people think that in order to advance a case of discrimination, that you have to prove that it was because of my race I didn't get a job, and only because of my race. Or it was because of my race that I was pulled over, and only because of my race. No, there can be other factors at play, right? But if your race was a factor, right? So if the individual who didn't offer you that apartment, didn't like the way you were dressed, didn't like your car, didn't like your smile, but also didn't like your race, right? So you see, race was just one of the factors. You still can have a successful case before the HRTO. Evidence. A lot of people get concerned. It seems highly technical. The lawyers in the room, if there are any, will be more comfortable dealing with the rules of evidence and the types of evidence that are admissible. But I just want to sort of provide a basic run through here. And by and large, a lot of the evidence will come from the person who experienced the discrimination. So your ability to retell that story in a compelling, truthful, honest way is the most important source of evidence in the cases that I've dealt with. Certainly anything that you can do to improve the quality of your quality and reliability of your evidence will certainly go a long way. So witnesses, documents, all of that's any support, anything that supports your telling of the story, or may refute the respondent's telling of the story, can be of great assistance to your case. If you're moving towards a hearing, be mindful, and you'll be guided through this, that the HRTO does have rules of procedure. So you will be required to disclose your evidence prior to the hearing. It's not trial by fire. You're not trying to surprise anyone. It's a civil proceeding. You are to disclose your evidence in advance, as the respondent will be, and so that will allow you to make your best arguments prior to the day that you have to advance your case in a hearing room, or perhaps virtually in this new COVID world. If you are successful at a hearing, the vice chair will consider your request for a remedy, and they will decide what is appropriate based on the circumstances of your case, as well as the case law, right? The adjudicators are not strictly bound by case law, but it provides case law provides a pretty strong roadmap for determining what type of remedy your case will receive. So, it's unfortunate that right now cases with respect to racial discrimination before the tribunal are not receiving huge sums of money, or the amount of money that I perhaps think that they should receive. There was a case involving a high-risk takedown of a Black male called Maynard, which I believe is the highest, received the highest amount of damages. I believe it was 40 or 45,000. And the case that I worked on called JKB versus Peel Police that received 35,000. That's the high watermark. So, when you're hearing about cases that receive large sums of money, they're probably civil cases. They may be cases from the United States, and not cases that are heard before the Human Rights Tribunal of Ontario. I will end my comments here because I think I've gone over time, and I've listed 3 cases where issues with respect to anti-Black racism were successfulully litigated before the Human Rights Tribunal of Ontario. And perhaps if there's time in the Q&A, I'll canvass any of your questions, or perhaps any issues that may relate to one of these cases. But I encourage all of you to have a look. if you're thinking about advancing a race-based case before the tribunal.
Thank you so much. That was, you definitely demystified the system, I would say. Thank you for that. And I really enjoyed the audience participation in those questions that you put forward. Okay, so I'm going to switch. I'm going to stop sharing my screen. I'm going to hand things over to Sasha.
Hey, thanks, Piera. I'm just going to try to share my screen here. Okay, are we seeing my screen? Yeah.
Yes, we are.
Okay, great. Well, thanks again, Piera, and thanks so much to BLAC for hosting this event and for inviting me to participate. I'm really, really happy to be here. I just think that the human rights system is such an important potential avenue for access to justice for our communities. So as Roger said, the extent to which we can, try to demystify it as much as possible, the better it will be. So, and hello to everybody joining us from Ottawa, Toronto, and all across the province. Thanks so much for joining us today. So before I start, I'll just say that, even although I'm counsel for the Canadian Human Rights Commission, today I'm speaking in my own individual capacity and not strictly on behalf of the Commission. So just want to give that caveat. Okay, so Roger's done a great overview of the Ontario human rights system. And now I'll take a few minutes to do a brief overview of the federal human rights system because there are some important differences. So first of all, what is the federal human rights system? It's a system aimed at preventing and addressing discrimination perpetrated by or within federally regulated organizations in particular. And it's all completely governed by the Canadian Human Rights Act. So almost everything you need to know about that system is in the Canadian Human Rights Act. And the key players are really the Canadian Human Rights Commission, the Canadian Human Rights Tribunal, and the federal courts. So the Commission is the body that receives human rights complaints, assesses them, and decides whether or not to send it over to the tribunal for a hearing. And the Commission also plays other roles, like, for example, it has a public education mandate. So if you go on the Commission's social media, you'll see, different postings about, human rights issues and things like that. So that's generally the role of the Commission. And then the tribunal is like a human rights court. So that is the body that is ultimately deciding whether or not discrimination occurred, and if so, what are the remedies that you're entitled to? But it is supposed to be less formal than a court. So that's one benefit to complainants, is that it should be a little bit easier to access. And then finally, the last kind of key player is the federal court system. So the federal courts play kind of a supervisory role in a way over the Commission and the tribunal. So if you receive a decision from the Commission or the tribunal that you think is wrong or you're not satisfied with, you can challenge that decision in the federal court and ask the court to review it. And the court has the power to overturn that decision and send it back to the Commission or the tribunal to be reconsidered. Okay, so in terms of who can complaints be filed against? So in the federal human rights system, you can file a complaint against any federally regulated service provider, employer, employee organization, First Nation government, any of these federally regulated entities that you believe has engaged in a discriminatory practice as defined by the Canadian Human Rights Act. And we'll get to that in a second. So these different entities can include basically any federal government department. So very important for those of us living in Ottawa, where a lot of people work for the federal government here. Crown corporations and agencies, banks. So many of us may have had experiences of being racially profiled when accessing banking services, or banking while Black, as it's been called. Airlines, trucking companies, telecommunications companies, any kind of interprovincial transportation company, radio and television broadcasting. These are all the types of entities that complaints can be filed against. So in terms of federal government departments as well, that would include the RCMP. In terms of policing, Canadian Border Services, Correctional Services Canada. We get quite a number of complaints from federally incarcerated inmates against correctional services. So these are all the types of entities. And then in terms of what really your complaint can be about, what are the discriminatory practices that are prohibited? So like the Ontario system, first of all, it's got to be a complaint of discrimination or harassment that's based on one of the following grounds of discrimination that we've listed here. And these are all also listed under Section 3 of the Canadian Human Rights Act. So, race, age, disability, any of those types of grounds. On the complaint form, when you file, it will ask you to identify which ground you are alleging that you've been discriminated on. So it's important to note that you don't have to just identify one ground. If you think that there are multiple grounds engaged in your complaint, then you're welcome to, check multiple boxes. So we know that as Black people, our identities are multifaceted, and it could be that perhaps you were discriminated against on the basis of both race and sex, or race and disability. So you shouldn't feel confined to just checking one ground necessarily. And I will say that you can see this in the Commission's annual report, but the highest number of complaints that the Commission receives are on the ground of disability. But then the second highest number of complaints received are on the grounds of race. So I think that says a lot about, unfortunately, the prevalence of racism in our society. Okay, so once you've got, it's a complaint of discrimination or harassment based on one of these grounds, the second thing is that it's also got to be in one of these areas. So it has to be related to the provision of goods, services, facilities, or accommodation. And I think, like Roger touched on, the definition of services is quite broad in human rights law. So that can include, anything, any kind of entity that provides a service to the public. So that does include police, that includes the airline you use, that includes Canada Border Services, that includes, the banking industry. So it's quite broad. It can also be related to the provision of commercial premises or residential accommodation. It can be related to employment. It can be related to the publication of discriminatory notices, signs, symbols, emblems, or sometimes we'll receive complaints of retaliation. So this is where you've already filed a human rights complaint. So let's say you filed a complaint against your employer, and then, shortly after you're terminated, or, some other form of retaliation. You can then, you do have the option of filing another complaint saying that, you've been retaliated against. So these are kind of all of the possible areas. I would say that most, like the vast majority of complaints that we see in the federal human rights system are complaints of discrimination or harassment in services or in employment. So those are kind of the two main streams. Okay. And then in terms of how are complaints filed? So at the federal level, it's a bit of a different system in that you don't file your complaint directly with the tribunal like you do in Ontario. In the federal system, you would file your complaint with the commission. So the commission plays a kind of gatekeeping function. So that's the body you go to. The commission's website is really good and has a lot of the information that you need to understand how to file a complaint. And it has an online complaint form that you can fill out and submit. So you can submit it online, or you can print it out, fill it out, submit it by mail, or you can phone the commission and submit your complaint by phone. As in the Ontario system, complaints must generally be filed within 12 months of the discriminatory incident. And there are some exceptions to this rule. So for example, if you had, a severe illness that prevented you from filing before the 12 months, you're welcome to provide an explanation of that, but ultimately the commission will decide whether or not to allow you to file that complaint beyond the 12 months. And also our act allows for complaints to be filed by either the victim of the discrimination or by someone on their behalf, as long as there's a written consent provided by the person that you're filing a complaint on behalf of. Okay, so what happens once your complaint is filed? There isn't really one set procedure that's followed in every single complaint. The commission has a lot of discretion to decide how it deals with, each individual complaint. But essentially, these are the kind of the general steps that might be followed, more or less. So first of all, you can expect that an intake staff person might contact you shortly after you file your complaint. They may ask you some clarifying questions, if there are some basic details that are unclear, or, just to ensure that your complaint was properly filled out, things like that. And then the commission will send a copy of the complaint to the respondent. So that's how the respondent will realize that you've filed a complaint against them. And then you might be offered mediation. So this is an opportunity to sit down with the respondent to see whether or not you can both arrive at a settlement agreement so that you don't have to go forward with the complaint. And there's also the possibility that the commission could choose to dismiss your complaint on more of a preliminary basis if a few of the following factors are met. And these are all listed under Section 41 of the Canadian Human Rights Act. So for example, it could be that maybe the commission feels that you have a grievance procedure. Let's say you're a unionized employee. They feel that you have a grievance procedure available to you and you haven't exhausted it. It could decide to have you go and exhaust that procedure. Usually, it's usually instead of dismissing your complaint, the commission might put it on hold while you go and exhaust that process. And then if that process is not satisfactory to you, then you come back and your complaint can be restarted again. So this is a discretionary decision. It's not in all cases that necessarily just because you have a grievance procedure, your complaint would be dismissed. The commission will do a case-by-case assessment. The commission could also decide that perhaps your case is better dealt with under another act. So for example, the Canada Labour Code or the Canada Transportation Act. So in those cases, it could dismiss it for that reason. It could decide that your complaint is outside of its jurisdiction. So for example, you bring a complaint against the Ottawa Police Service, which is not under federal jurisdiction, that would dismiss your complaint. Or it could find that your complaint is, in the words of the Act, trivial, frivolous, that it's already been dealt with somewhere else, or that it's out of time, as I mentioned. And in terms of next steps, your complaint could also go through an investigation or assessment process. So that could include a phone interview with yourself or other witnesses. And then usually a report is written up, and you would have the opportunity to make submissions on the investigator's report that's been written. And finally, the commission could also decide to do a conciliation. So that's basically like a mediation, where it's, this is a very specific process that the Act gives the commission power to order parties to participate in a conciliation. So a type of mediation to see whether or not they can arrive at an agreement. And then, in some cases, the commission will say, okay, if you can't agree, then we'll send it to the tribunal or whatnot. And then the last step is always that the commission then ultimately decides whether or not it's going to dismiss or to refer your complaint. So as I said at the beginning, if the commission does dismiss your complaint, you can challenge that decision at the federal court. But let's say that the commission refers your complaint to the tribunal. What happens then? So in that case, the tribunal now becomes the decision maker and a completely new process begins. A lot of people tend to think that, somehow the commission's the tribunal kind of just picks up from where the commission left off and, just kind of, takes all of the investigation that the commission has done and makes a decision based on that. No, that's not the case. It's a completely new process that restarts. The tribunal is an independent body, and it decides, your case based on evidence that's before it. So just because the commission may have contacted a witness during its investigation, that doesn't mean that you don't have to call that witness to come and appear before the tribunal. So everything starts afresh. The tribunal might also, well, it doesn't might, it will definitely offer you mediation. So this mediation is going to be done by a member of the tribunal, which is one of the decision makers on the tribunal. And if mediation fails, then steps to prepare for a hearing begin. So one of the first steps is for what's called a statement of particulars to be filed. So you'll be asked, and the respondent will be asked to, file this document, the statement of particulars, where you overview all of the facts from your perspective, the issues from your perspective, what remedies you're looking for, what witnesses you'll be calling. So you'll provide that. And both you and the respondent, just like in the Ontario system, will have an obligation to disclose all documents in your possession that are in any way arguably relevant to your complaint. So this is a really important legal obligation for complainants, especially in race-based cases. Well, I would say in all cases. Because a lot of the times it's the respondent that has, very helpful documents that could be very helpful to your case, right? So maybe it's, emails back and forth between that's solicitor-client privilege, let's say, where it was a communication between them and their lawyer. But other than that, they've got to disclose, you know, all documents. You may also decide to call an expert witness. So another part of the process might be that you retain an expert witness and you have them provide an expert report about your case. In the process, there could also be some preliminary motions that the tribunal has to decide. So for example, you know, one common issue that comes up between the parties is that, you know, let's say you've requested that the respondent disclose certain documents that you think are relevant and that they haven't disclosed, but they refuse to disclose them. Well, you can bring a motion, which is just a fancy way of saying, you know, bringing kind of a request to the tribunal to ask the tribunal to respond to release all of those documents to you, right? So there may be some preliminary things like that that have to be dealt with. And then ultimately there's a hearing, which, you know, involves, you know, the typical things a hearing would involve: an opening statement, the witnesses are called, and your closing arguments, and also, you know, you providing documents that you'd like to be entered in as exhibits. Okay, and so in terms of the remedies that are available to you, so these are the remedies that the tribunal can order. They can order for the respondent to stop the discriminatory practice. They can order for the respondent to make available to you any rights or opportunities that were denied. They can order compensation for any lost wages that you may incurred or any expenses that you may incurred as a result of the discrimination. And here's a key difference between the provincial and federal system in terms of money that you can get for pain and suffering. Unfortunately, there is a cap under our act, under the Canadian Human Rights Act. It is a cap that, in my opinion, needs to go. It's been about 20 years since we've had this cap, and it hasn't adjusted for inflation, but here we go. It's what's in the legislation, so that's what we're stuck with. So it's that you can only receive up to $20,000 in pain and suffering. And you can also receive an additional $20,000 if the tribunal finds that the discriminatory practice was committed willfully or recklessly. So in total, you could possibly be looking at $40,000 in general damages. And on top of that, if it is a situation where you have lost wages as a result of the discrimination, then you can, you know, also get an additional amount for the lost wages. But in terms of general damages, it's really those caps that apply. You can also get interest on those amounts. So let's say you brought your complaint years ago and the hearing only took place, you know, yesterday. You know, you can get interest that accumulates on those amounts. And then finally, but I think, you know, very, very importantly, you can also have the tribunal award systemic remedies. So these are things like policy changes, like things like ordering the respondent to undergo training in anti-Black racism, or things like that. And again, you know, you have the federal court as an avenue to challenge a tribunal decision that you may not agree with. And lastly, just important to, in terms of some other important points to clarify, there's no fee for filing a complaint with the commission. You don't need a lawyer, so it's not mandatory. In fact, the system is supposed to be designed to be friendly to self-represented litigants. Of course, a lawyer is helpful, and if you can access one, great, but it's not mandatory. It's usually a lengthier process than complainants anticipate, unfortunately. So, you know, you have to kind of go through the commission and then the tribunal, and It really varies depending on the nature of the case. So it could be that, you file a complaint and, the commission, really deals with it relatively quickly, but then you get to the tribunal and you may be waiting a year or two for a hearing. It really varies, but I do find that the process tends to be lengthier than what most complainants envision. Like I think Roger mentioned, in the Ontario system, I would say in the federal system as well, most complaints do result in a settlement. So it will either settle either at the commission stage of the process or once it gets to the tribunal. So, not a bad idea for people to take advantage of the mediation opportunities that may be presented to you. You never know. And then I think, lastly, I would say that we all know that the experience of racism can be very traumatizing. And unfortunately, participating in any legal process, I think, to get justice for what you've experienced can be re-traumatizing. You're having to relive the experience, by writing about it, talking about it, and then you may have it dismissed and feel like you haven't been believed. So it's, or you go through a hearing and you're hearing the respondents say all these things that to you are just lies. So it can, be a difficult process. So I would say, important definitely to guard your mental health and practice self-care while going through these processes. Okay, so I think I'm a bit out of time. I did want to touch on a couple of case law examples, but I may not have the time to do that. But here are 3 cases that are accessible online. So there's a website called Canley, that's CANLII. And if you type in the citation, so let's say the first one, 2019 FC 579, you will be able to read the case for yourself. These are, interesting cases. Peterkin versus TD Bank was a case of banking while Black. Miss Peterkin, requested to withdraw money from her own account at TD. It was initially rejected. That request to withdraw her funds from her account was rejected by the bank teller. It was quite a large amount that she wanted to withdraw. This was despite the fact that she entered her PIN and showed 5 pieces of ID. An argument ensued, police were called. Eventually, hours later, she was allowed to withdraw the funds. But this was a case where the commission had dismissed the complaint on the basis that the bank was applying a valid ID policy. There was no evidence that her race was a factor. But then Ms. Peterkin challenged that decision at the federal court, and the federal court overturned the commission's decision and sent it back to the commission to reconsider. So the court felt that there were very key allegations that weren't looked into enough by the commission. So these are a few of the allegations there in terms of her interactions with bank staff. So that's an interesting decision to look at for sure. And then, I do want to say, when we look at these bullet points, we look at all of the kind of subtle facts and all of the circumstances of Miss Peterkin's complaint. So the fact that she, entered her PIN and showed 5 pieces of ID, and there was some aggressive kind of behavior by the bank manager. She somehow was waiting outside for 2 hours with police. Things like this is all considered evidence. So this is what we call circumstantial evidence. It's the subtle, it's all of the circumstances, all of the facts that combined raise a kind of a red flag, possibly, right? So a lot of the times in race-based cases, it's not that there is some, smoking gun document that just proves that what you experienced was racism. It's that the tribunal, the decision maker needs to look at all of the circumstances and see whether what the Canadian Human Rights Tribunal calls it, whether there's a subtle scent of discrimination is what they call it, right? So that's what needs to be shown. And then the other interesting case to look at is Turner. So this is a Black man who worked for CBSA, had positive performance reviews for 6 terms in that position, but wasn't found to be qualified to participate in a competition for indeterminate position for an indeterminate position at that level. And the tribunal did find that race was a factor in the decision to disqualify him from the competition. And I would say really take a look at this case because A, it's recent, and B, it has a lot of great quotes in it about the legal framework that the tribunal is supposed to apply when assessing these types of race-based cases. And it's got a lot of good emphasis on the fact that, oftentimes racism or racial bias manifests in very, very subtle ways, or the perpetrator of it doesn't even know that they're being racist, but that it's completely unconscious. And that all we're looking for is a subtle scent of discrimination. So nice quotes to have access to, right? And there's parts of the decision that talk about the prevalence of anti-Black racism in society, such as this one here. The tribunal then goes on to talk about, some of the stereotypes that are attached to Black males. So a lot of gems in that decision that, if you're bringing a complaint either in the federal system or even in the Ontario system, some of these quotes from the decision could be helpful. Okay, so I'm over my time, so I'm going to leave it there. Sorry, Piera, for going longer than I should have.
No, that's all good. Thank you. That was really, really interesting. And I think this is a system that people are not necessarily that familiar with. So thank you for sharing that with us.
My pleasure.
Okay, so we've gotten lots of questions, which is great. Can we also get Roger back here? So I'm just going to try and pick up on some themes that have come through because we won't be able to get to every single question. But just to pick up on what you were just saying, Sasha, like at the end, how often these experiences can be very subtle. So I've seen some people mention in the chat, how do you prove your case? And Roger, you touched on evidence and the fact that evidence can just be the person telling their story and how important that is. But a question that's come up is, a few people have asked this, is about the remedies and why they are so low. And maybe you could just talk a little bit about why you think they're so low, especially in cases related to race. And yeah, I'll pass it on to you both.
Did you want to go ahead?
That's a tough question, right? I don't think that there's a clear-cut answer to that. I will preface my response by saying, by and large, the awards before the Human Rights Tribunal of Ontario are on the lower end of the scale, right? Of people's imagination. Even before going to law school, even myself, I'd constantly hear about people suing for millions of dollars. Someone spills hot coffee on somebody, they get, you hear about these cases from the United States and sometimes from Canada. But the reality before the Human Rights Tribunal is that the general damage awards tend to be, in the 25K and lower range. That's for all grounds of discrimination. The exception to that recently has been in the area of sexual harassment. We're seeing damage awards creeping up, 50,000, 75,000 in that range. And again, this is not this. I'm pointing to some high watermark examples, not what the I hate to use the word typical because these are people's experiences, not what you would see in the typical case. So awards are low. There has been some movement in the area of sexual harassment, and of course, we'd like to see awards with respect to race-based discrimination also start to trend upward as well. But like I said, a lot of it is determined by past precedent.
Right, and as low as Ontario awards may be, I have a feeling the federal awards comparatively are probably even lower because of that cap that I mentioned, which, I think possibly an important advocacy issue for our community to get behind. It is an access to justice issue. It's quite low. So 20,000 is supposed to be reserved for the most egregious cases that we're talking about, right? So you can imagine then, how much lower, awards might be for your run-of-the-mill cases. So yeah, I think it's important to keep pushing for higher awards in race cases, just like we've seen the trend in sexual harassment cases go higher. And in terms of, you said there were other questions about evidence, how do you prove race-based discrimination? I mean, I would say race-based cases are amongst the hardest cases for complainants because of exactly what the case law says about them, that, racism tends to manifest itself really subtly. I also find, being in the Canadian context where there's this myth that racism doesn't exist here or somehow we're much better than our US counterparts, you're going up against, this myth as well that, perhaps you're exaggerating or, what you've said, didn't really happen. So I think for all those reasons, it can be really challenging, but I think, Roger had touched on a few points in his presentation about this, about the fact that, your version of the story said in an honest, compelling way before the tribunal is an important source of evidence. The respondent may come and say something completely different, and then it's up to the tribunal to do a credibility assessment, essentially, and basically decide who they think is telling the truth. So there's your own testimony. If there were witnesses there, you can ask witnesses to appear and to testify about what they saw. As I mentioned, documents sometimes can be helpful. Maybe there are some internal communications that in the respondents corner that you don't know about and that you might get access to through the disclosure process. And certainly, if any respondent is not willing to disclose those documents to you, then you bring a motion and you ask the tribunal to order them to disclose it. Those documents can also be about systemic things that might help your case. So, there was another case I didn't get to touch on, but it was an example of racial profiling of an Indigenous woman by Canadian Border Services at the border. And, documents were requested about training that were provided to Border Services agents about anti-Indigenous racism and racial profiling and things like that. And there was, the result was that they weren't doing that training. And that was also an important piece of evidence for the tribunal to see. And that led to an award that, that CBSA deliver that training, right? But I think, so in addition to all of those things, I think the most important thing, though, is to always make sure that as race-based litigants, we are putting before the decision maker the correct legal framework and the correct lens that they need to look at these cases through. So, you know, that Turner case sets out a lot of the key principles that I mentioned. We need to put those principles before them and make sure that they're assessing whether there's enough proof for your case through the right lens. And so part of the lens tells us that there is no need to have what's called direct evidence to prove that race-based discrimination happened. Circumstantial evidence can suffice. So you don't necessarily need a document that shows that they called you a slur. Like you know, your testimony coupled with all of the nitty-gritty parts of the circumstances can all be part of the evidence. Another thing the legal framework tells us is that there's no need to show that the person intended to discriminate. It could be completely unconscious. The legal framework tells us that we don't need to prove beyond a reasonable doubt that racism occurred. It's the balance of probabilities, meaning, is it more likely than not that race was a factor in your case? So you see, like, all of these things about the legal framework and all of these principles are key. Like if any of them are forgotten, then you could end up in it, like having to meet a higher threshold than what you're actually supposed to meet. So always worth reminding decision makers of those fundamental principles too, I think.
Thank you. I'm just conscious of time. So I want to just let everyone know, first of all, that yes, we will be sending out the slides because there's so much great information in there, especially the cases that both Roger and Sasha mentioned. I would encourage you to check out CanLII. You're not going to believe me, but it is fun to read case law because you get the narrative of the person like telling their story, and then you get to see how the tribunal addresses each of the different legal issues and comes to their decision. So I think with the context of everything we've said today, it'd actually be kind of fun to read. And also this is recorded, so this will be available. So if there are people who weren't able to join, or if you want to take a look at this again, you will have access to this. So another theme that's come through is about the time frame that it takes to like go through this process from the application to decision. And also there are some questions about limitation periods. So maybe Roger, if you want to respond to this and maybe just address some of the circumstances where a limitation period can be extended. If you can give some concrete examples.
But just before I get to that, I just wanted to reiterate some of the things that Sasha had mentioned, that they are also applicable to the Ontario context. When proving a case of racial discrimination, intent is not required. Another point that's important to remember is that the law recognizes that racial stereotyping can be the result of subtle unconscious beliefs that expose an individual's prejudice. So the point that Sasha made about cross-examination is key. Sometimes you don't have the evidence in hand, and you may not get that evidence until you get into the litigation process, or sometimes it comes on the day of the hearing when you're able to have an opportunity to cross-examine the respondent's witnesses. And that's why it's helpful to have a lawyer to conduct a cross-examination with respect to racial discrimination. But in the Ontario system as well, it's not a specific requirement to have a lawyer. The direct access model was sort of designed to give individuals their day in court. I think that was the language used by the government of the day. And so, and the last point I'll make about evidence is that in addition to having the evidence, you want to be able to help the tribunal understand the evidence in the light that you want it to be understood in. And sometimes, you start that process, perhaps with your opening statement, with your closing statement, and by, you also have an opportunity to put authorities before a decision maker. And when I say authorities, I just mean articles, right? So if you have, journal, peer-reviewed journal articles about race or racial discrimination, perhaps, the OHRC's policies is another great thing to put before an adjudicator. And by and large, adjudicators are aware of these things, but I think it's also helpful to remind them. In the JKB case that I litigated, I was, careful to put that type of evidence before the adjudicator, because, there aren't a lot of cases about racial discrimination against Black women. Even fewer cases about, a young Black child, right? So oftentimes when you're discussing racial stereotypes, we think about, driving while Black, the young Black man in a hoodie. We don't often think about how racial stereotypes operate against other members of the Black community or other racialized groups who are also victims of racial discrimination. There's also an additional point to make, about expert evidence, but it's not often required. Sometimes if you're dealing with a particular novel issue, you may want to call on an expert to give evidence or to help the tribunal understand the evidence that you're given. But it's something that you'd probably want to research before beginning to do so. In terms of extension of time, it's very difficult to get an extension of time. Sometimes, like you have to show the tribunal that you were not in a position to file the application. It's it's very lay way of explaining it, right? There have been a few exceptions with respect to health related concerns, like if you were incapacitated at the time. Sometimes there have been cases where the application is just filed just outside of the limitation period, like a couple of hours, and the tribunal has or a day or so has excused those types of technical breaches or people who have misinterpreted things. So it's difficult, but there have been cases of that nature. I think there's also one case that I remember where the applicant was trying to argue that I was I think it's medical. I think I'll leave it at medical exceptions. I don't want to get too much into the weeds of it, because the establishing an exception to the rule can be difficult. Maybe if you're given incorrect legal advice, perhaps that might be another exception that has been acknowledged by the tribunal, but it's as I said, it's difficult.
Mm-hmm. I can jump in for a second because someone is asking, Sasha, in terms of, let's say you file your complaint with the Canadian Human Rights Commission, and you go through a bunch of stuff with them, and then they decide that they're not going to proceed with your case, or you're in the wrong place. Like, let's say you're in the wrong jurisdiction. What if your limitation period has expired where you were actually supposed to file? Would that, be an opportunity to sort of argue for an extended limitation period? Let's say it was at the HRTO or something.
So I don't know exactly how the HRTO would handle that, but I mean, I would think that would be, a bona fide reason perhaps for them to allow an exception to the rule. If you can show proof that you were trying to get through in this other system. But I think for things like jurisdiction like that, the commission's decisions tend to be fairly quick, because it's usually fairly obvious if it's, really not within our jurisdiction. So I think it would be a rare event for your case to just kind of be languishing there when you filed against an entity that's clearly provincial, and you should be somewhere else. So so I don't think that scenario would happen too often.
Mm-hmm. Thank you.
Yeah, but someone did ask a question about the length of time that the whole process takes.
Mm-hmm.
I think, it really varies. It's really difficult to say. It depends on the nature and complexity of the complaint. There are really simple complaints that have to do with one incident. And, you know, there are also complaints that are huge systemic issues, you know, on behalf of, you know, a large class of people. So obviously those will take a long time. Your regular, not that complicated case, I still think that if you were to get a hearing at the tribunal 2 years from when you filed your complaint with the commission, I think that would still be considered good timing in our system. But yeah, it's really hard to give an average time.
Mm-hmm.
The same for Ontario. It's hard to give an average time from starting your complaint to a hearing. Could be 1 year, could be 2 years. So if I were to give any kind of answer, honestly, I would be guessing, because I've seen so many different variations. The one exception I will make to what Sasha said, under the Ontario system, you know, based on what I've seen, if your case is clearly outside of the jurisdiction, by and large, you will get a quick response. But again, you know, there are a lot of people file in applications, and sometimes you may not get a quick response. So you have to be very careful, because the HRTO will consider your ability to file before another body as almost a strike against you, right? Like you had the wherewithal, you knew you had to file, you filed for a wrong body. So, you know, why didn't you also have the wherewithal to sort of take proactive steps to make sure that you were in the right spot? So this provides a good opportunity for me to plug the Human Rights Legal Support Center's self-help guides. They are tremendously helpful, in addition to giving them a call about a jurisdictional issue. But definitely you want to do your research. And, you know, one of the best things you can do is manage that limitation period effectively, right? You don't want to be filing on the 11th hour, because that's when you sort of run into problems.
That's for sure. All right, well, I think maybe we should leave it there, just because it's a bit after 7, and I'm mindful of the time that you are taking to spend with us today, and the people who are joining us. We had like a very active chat, and lots of people were responding to each other and communicating, so that was great to see. I do apologize we weren't able to get to every single question, but I would encourage people, as I said at the beginning, to please reach out to BLAC if you do have a question, a legal question about your own circumstances. Also, the Human Rights Legal Support Center, as Roger said, really useful, and the guides are amazing. I often refer to them myself. So, and also the Canadian Human Rights Commission also has like really helpful information on their website.
And the commission as well. And I apologize for I was an employee of the HRLSC, but definitely if you can find legal advice at BLAC, at the BLAC Legal Action Center, or a, you know, community legal clinic, wherever you can sort of access that advice, I highly recommend that you speak to someone, just so that you don't trip over some of the stuff that Sasha and I presented today.
Yeah, exactly. All right, well, thank you so much, everyone. Have a lovely evening, and we'll see you again soon. Oh, before I go, I almost forgot something. I do want to mention something really quickly. So there's an initiative that BLAC is working on. It's called the Links to Justice Research and Advocacy Initiative. So this is something that's focusing on the school to prison pipeline, and they are currently looking to engage with the BLAC community across Ontario. And it looks like we do have quite a few people from across the province here this evening, to better understand their experiences and provide spaces for learning, increase access to resources, and to advocate for meaningful change and policy reform within our justice and educational system. So they are doing focus groups with students and parents all summer in Peel, York, Toronto, Hamilton, Durham, London, Windsor, and Ottawa. So I'm going to put a link in the chat. Feel free to check this out, but I just wanted to mention that to everyone here today. All right, Thank you very much and have a great evening, everyone.
Thank you. Take care, everyone.
Thanks for organizing this.
Yeah, thanks for coming.